And welcome back to Law&Crime Daily, everybody. We continue our coverage of the Murdaugh murder mystery in small-town South Carolina. Jury selection finished Wednesday afternoon with 12 jurors and 6 alternates picked. Now, one of the issues that the jury might hear in the coming days concerns financial crimes that Alex Murdaugh allegedly committed. On Tuesday, the prosecution and the defense presented arguments to the judge about whether or not to include those misdeeds in this criminal trial.
Mr. Murdaugh was confronted the very morning of the murder by his own law firm seeking missing fees. That's the temporal connection of those two events that then tie back to literally a decade of embezzlement that one question begets another, which begets another. To understand why these are significant, the jury has to understand that he had been stealing for over a decade, 99 counts to date, and facing essentially life without parole on these particular financial accounts, and that's the significance of what he was trying to prevent from being exposed.
The South Carolina Attorney General's office filed 99 charges against Murdaugh for these alleged financial crimes. In 19 indictments, he's accused of stealing more than $8 million as part of a Ponzi scheme. But the defense says, true or not, that has nothing to do with the murder of Murdaugh's wife and son.
There is no dispute anywhere that they were the perfect family in terms of their relationships. No divorce, no separated, no left him, no nothing. So this is a fabrication, and they want to use what Mr. Griffin described as bad character evidence. He stole all this money, so he must have killed his wife and son.
All right, let's dive into this. Brian, what decision did the judge make when it comes to introducing financial crimes as evidence?
The judge basically said, maybe. He ruled against the prosecution's motion in limine to introduce the financial crimes, but left open the option of arguing if the evidence should come in as the trial continues. The individual pieces of evidence of the financial crime face more scrutiny compared to getting a ruling before the trial. It's like a football coach being able to throw a yellow flag at every play or VAR for every tackle for my kind of football fans. As different witnesses take the stand, the judge is going to hear arguments outside the presence of the jury and witness as to whether or not specific evidence of that crime should come into this double murder. It makes the trial a lot harder for the prosecution. Instead of just making one argument and scoring 6 pieces of evidence, they have to go 6 for 6 to get as many points. It's just a different type of game.
Yeah, right, Brian. I mean, this could have repercussions down the line during trial. But in my opinion, the judge should have made a ruling either to exclude or to allow Murdaugh's financial records. By waiting for this trial to begin, there is a serious risk of delaying the entire trial. Listen, the whole point of a motion in limine is to determine evidentiary issues before the trial. When judges timely make those decisions, then the trial can proceed without extensive interruptions. The other issue, and this is really important, it also allows the parties to better prepare for their case. For instance, the attorneys, they need to know what they can say or what they can't say in the opening statements. It just makes life easier for everybody all around.
I don't know, Brian. Terry makes a pretty good point. What other reasons could the defense have for keeping that part of the case separate?
Well, one is we like to make cases difficult, but aside from that is I get the prosecution believes these crimes are connected, but I think the defense's response would be, prove it. Evidence doesn't come in just because the prosecution can dream it up, but because they can prove there is some relevance to the charges. Otherwise, the defense has a strong argument for keeping that evidence out or winning on appeal if the judge gets it wrong. In their motion, the prosecution argues that Murdaugh saw the walls closing in on him in the civil case, that the plaintiff's request for discovery was so strong and so imminent that it drove him to shooting his wife 5 times and his youngest son twice. A bizarre theory, but how did they come to it? But why would he do that? And the motion wasn't even decided before the murders, and in fact, a similar motion filed by another defendant in that case was denied, so Murdaugh probably would never have to turn over this financial information. Also, I don't see how a lawyer would be able to testify at trial that they knew the outcome of a trial or motion. Who do they think they are? A host of the Law&Crime Daily?
How dare they? I mean, so why is the prosecution pushing for it, Terry?
You know, actually the prosecution argued that it wasn't trying to predict what Judge Hall would eventually rule. Just to clarify, Judge Hall is presiding over that wrongful death lawsuit brought by the estate of Mallory Beach, and the Beach family requested those records because Murdaugh claimed he doesn't have any resources to pay. So the Beach estate has every single right to request those financial records under those circumstances. Now, the prosecution in this criminal trial, they also want those records, but they argued that the jury has to understand, you heard him say this, what has been happening over the past decade as far as the finances are concerned. And so that's why they want that in there. It's going to the motive. Frankly, I agree with the prosecution. All of this is relevant, it's more probative, and I think it should come in. And I think they should decide it now.
All right, you make good arguments. We'll wait and see. Stay with the Law and Crime Network for gavel-to-gavel coverage of the Murdaugh family murders. We're going to be bringing you the very latest here on Law and Crime Daily. And of course, you can check out everything from videos to court motions on Law and Crime.